Call on Government Order of the Day number 3.
Judicature Modernisation Bill, second reading.
The Honourable Joe Goodhue.
Mr Speaker, I move that the Judicature Modernisation Bill be now read a second time. This omnibus bill creates 5 new acts and amends 17 existing acts. The 5 new acts will be the Senior Courts Act, which sets out arrangements relating to the High Court, Court of Appeal and Supreme Court. The District Court Act, which does the same with respect to the District Court. The Judicial Review Procedure Act, which restates the existing process for seeking judicial review, but in contemporary language. The Interest on Money Claims Act, which puts the process for courts awarding interest on claims involving monetary amounts on a more defined and comprehensive legislative footing. Finally, the Electronic Courts and Tribunals Act, which paves the way for the use of electronic documents in New Zealand's courts and tribunals. Part 6 of the bill sets out amendments to 17 other acts, principally by relocating existing provisions of the Judicature Act or by extending certain provisions applying to the senior courts and the district court to our specialist courts. Mr Speaker, the Judicature Act 1908, which this bill repeals, is one of New Zealand's oldest statutes still in force. It is also one of the most important, forming the cornerstone of a set of statutes that provide for New Zealand's courts. In 2010, the Government asked the Law Commission to review that Act. In December 2012, the Law Commission's report was tabled, and 12 months later, the Government introduced this bill. We advanced this work because society and technology are changing rapidly, and it's increasingly clear that our justice system must be modernised to keep up with the demands of the 21st century. The bill modernises the legislation and arrangements relating to New Zealand's court system and provides scope for a more efficient system. The changes increase transparency, certainty and clarity. This will lead to greater public confidence in New Zealand's court system. While this is a very large bill, many of its provisions are not new. The bill does continue many existing provisions, albeit with more modern language and style where necessary. I wish to acknowledge the efforts of the Justice and Electoral Committee in examining the bill and commend the committee for their work on this significant piece of legislation. The committee received 25 written submissions on the bill and heard 15 oral submissions. The submissions came from the judiciary, professional organisations, interested groups and individuals. The submissions were thorough, and I understand they provided the committee with considerable focus in its deliberations. I will highlight a handful of the changes recommended by the committee. Along with other changes made, they collectively improve the bill's clarity and effectiveness. The reported back bill retains provisions establishing specialist panels in the High Court. It does, however, clarify that parties may request that a case be heard by a judge from a panel unless the Chief High Court judge determines otherwise. Also, Part 1's general rulemaking power is now relied upon for setting court rules needed for a panel's operation. The committee amended provisions giving courts the power to make graduated orders, which limit people who have initiated previous meritless civil proceedings from continuing or commencing more proceedings. The amended bill allows a court to make an order of its own volition. This will be useful in cases where the court has the best knowledge of a person's litigation history. The bill also clarifies the definition of meritless proceedings required before an order can be considered by the court. Courts will also have greater flexibility as to how long orders last. The orders may be imposed for any period up to 3 years rather than exactly 3 years. The 5-year time limit remains for cases involving exceptional circumstances. The committee has incorporated a government proposal to improve information sharing between government departments and other agencies. This will enable elements of court information, such as the existence of protection or restraining orders relating to a person, to be shared between these organisations. Sharing will only be possible through approved information sharing agreements permitted under the Privacy Act. The new provision will help deliver better public services. On a related note, the bill also adds certainty to the obligations of court registrars and the court with respect to disclosing certain court information, particularly convictions, to registration authorities. As a result of the bill, registrars must notify registration authorities unless the court specifically orders otherwise. This change will remedy instances where information has not been shared and so prevented a registration authority from taking appropriate action. The committee has made a number of recommendations specifically relating to the District Court. The bill, as reported back, confirms the unification of the District Court and the increase in the court's civil jurisdiction up to $350,000. Many other changes are of a minor yet necessary nature. I would emphasise the increase to the financial value of tools of trade and necessary household furniture and effects that may not be seized from a judgment debtor. This increase matches the High Court's threshold and so better protects debtors from unfair seizure of basic assets. It removes an anomalous difference given the purpose of the two thresholds is identical in each case. There are several changes made to Part 4 of the bill relating to interest on money claims. Of note is an amendment widening jurisdiction of the new Act to include amounts under $5,000. This reflects that modern technology now enables ready calculation of interest on small amounts. Not so long ago, the cost required to confirm this calculation would have very likely offset the value of the interest awarded. Part 5 allows our courts and tribunals to become electronic. The revised Part 5 makes a further nod to modern technology with a new regulation making power enabling classes of court users designated by regulation to be required to use electronic documents. This change recognises that some categories of court users, such as lawyers, are and should be able to deal electronically in order to achieve the full benefits of electronic courts and tribunals. As part of wider consultation on the bill, questions have arisen about including reference to commitment to the rule of law, principles of the Treaty of Waitangi and parliamentary sovereignty in the purpose section of this bill. After close consideration, I do not consider such statements sit properly in this bill. These are commitments of a constitutional nature that best belong in the Constitution Act rather than this bill, which only governs the architecture of certain courts. I conclude by saying that this bill is not only notable for its considerable length, but also because of the significant contribution it makes to modernise aspects of New Zealand's court system, and I commend this bill to the House.
The question is that the motion be agreed to. Jacinda Ardern.
Mr Speaker, thank you for the opportunity